In this essay, I will illustrate that because of their inherent ambiguity, coupled with a lack of personal incentive that exists with private citizens in pursuing public affairs, constitutions or constitutional systems are vastly less superior at securing liberty than private contracts enforced in a private law society. Citizens themselves have a hand in making. A common misconception is that the United States Constitution forms a contractual legal agreement between citizens and their government. After all, it says, "We the people," in order to form a more perfect union, establish this Constitution for the United States of America. But who are these people? Certainly those of us who were not even born when the document was foisted upon the American people have little or no obligation to it. This is the difference between a legitimate and legally binding contract, which must have the implicit consent of all parties involved, and constitutions. The standard argument against those who don't wish to be bound to a document they don't agree with is, well, why don't you just move to Somalia or something? Why should I, a property-owning American, have to forego my natural and inalienable rights to the property in my own person and territory have to move? Certainly those that support the moral right of secession must agree. Not only do states have the right to opt out of their government, municipalities, counties, cities, and individuals do as well. After all, how can you delegate a right to an exterior body you yourself don't have? It is illegitimate and unjust to conscript individuals into a system they may not wish to be a part of, just because they were born inside the boundaries of an arbitrary territorial political monopoly. Imagine going to court in order to pursue legal action against someone for violating an agreement they didn't even sign to or agree with. The judge would laugh in your face. One argument I have made before is that constitutional limited government depends on the sustained vigilance of the population to function correctly. Private contracts require little increased vigilance or knowledge on the part of the citizenry, however. Acting man who consistently pursues his own rational self-interest maintains a higher level of vigilance in his own private sphere than he does in the public or political space. To illustrate this, think about the last time McDonald's made your cheeseburger wrong. Did you go home and blog or make a YouTube video about it? Or did you angrily demand that they make it right and get what you paid for? Undoubtedly, McDonald's, who wishes to keep your business, remade your burger for you, even if they weren't nice about it. Compare this to the political realm. What did you do when the NSA made your surveillance wrong? Or when the U.S. military made your defense wrong? Did you feel like you had the power to demand remuneration? Did you demand redress? Did you march right up to the U.S. Capitol or to the government offices and tell them to make your burger right? Did you write your congressman? Did you make calls? Did you launch protests? Did you file lawsuits against them for violating the Constitution? Or did you go on the internet and complain about it? Even if you did do those things, which few people are inclined to do, did the U.S. government listen to you anyway? Did they rectify the situation? Did you feel like your opinion even counted at all? Of course not. Individuals have much more influence in their private lives and have a personal innate preoccupation in preserving such interests when interacting with other citizens and businesses that requires little increased education or political awareness. This is not to say that some level of vigilance isn't required to enforce private contracts. The point, however, is that there exists much more incentive to enforce mutual obligations in one's own personal associations. The majority of people are more likely to seek redress against their home builder for building a shabby foundation that collapses, for example, than they are against government for violating said home or property. Individuals are also much more likely to succeed in gaining such redress privately, especially when contracts contain clear property descriptions and stipulate what is to be done if the home builder fails to fulfill his obligations. It is in one's own immediate and tangible self-interest to ensure such safeguards in his private and personal life. The Constitution contains no such descriptions and is instead a sweeping judgment that neglects individual preference and unique circumstance. Let me just say here that I do support the Constitution within the current political framework and consider it paramount to challenging the abuses of the state. If you have been a longtime subscriber of my channel, you have undoubtedly heard me make constitutional arguments. The fundamental flaw in the constitutional system, however, is that constitutionality is determined by the very same institution under consideration, government. As long as government has the sole authority to decide for itself whether or not what it does is constitutional, there can never be justice. In a private law society where contracts contain clear property definitions and means of redress, mutually agreed upon independent outside arbitrators would be much more impartial than the state apparatus otherwise would. Imagine receiving food poisoning from McDonald's. Would you feel comfortable having your case heard by a court owned and operated by McDonald's? Why then do you expect Supreme Court judges, either politically appointed or otherwise, to maintain some allegiance to a document that limits the power of the very same institution on which their careers depend? As we have seen over and over again, and while there are some small constitutional wins here and there, the separation of powers envisioned by the founders is almost entirely non-existent. As I've stated in the past, the Constitution represented an increase in the growth of government in the United States, and I believe was left intentionally vague, especially surrounding things like government regulation of economic activities engaged in by private citizens. Whereas the Articles of Confederation took 5 years of deliberation, the U.S. Constitution was pushed through only after 3 months. The Constitution was a usurpation of liberty and an elitist document signed for the most part by English aristocrats for the admitted purpose of gaining control over the national territory and dividing the populace. James Madison, who is widely considered the father of the U.S. Constitution, though that claim is debatable, openly admitted this. During a debate on the Constitution, Madison stated the following: "Where a majority are united by a common sentiment and have an opportunity, the rights of the minor party become insecure. In a Republican government, the majority, if united, have always an opportunity. The only remedy is to enlarge the sphere and thereby divide the community into so great a number of interests and parties that in the first place a majority will not be likely, and at the same moment to have a common interest separate from that of the whole or of the minority, and in the second place that in case they should have such an interest they may not be so apt to unite in the pursuit of it." So here we have James Madison candidly advocating divide and conquer strategies during constitutional debates. Pulitzer Prize-winning historian Dr. Forrest McDonald, who is considered one of the foremost authorities on the U.S. Constitution and of the early national period, writes, "The first function of the founders of nations after the founding itself was to devise a true set of falsehoods about origins, a mythology that will make it desirable for nationals to continue to live under common authority, and indeed make it impossible for them to entertain contrary thoughts." The U.S. Constitution was written not with the intention of creating a free society, but to create a political system of an ever-expanding federal government at the expense of individual rights and state prerogatives. Benjamin Franklin, James Madison, and Alexander Hamilton were 3 of the men who framed the document and pushed for its ratification. Their document served the American aristocracy, not the people. In fact, the document was never put before the people for ratification, and was openly opposed by the majority of men and women in the original 13 states. In fact, the names of the signers were kept secret for an entire generation for fear of reprisal from an angry populace. The Constitution was created on September 17, 1787, and was ratified behind closed doors on June 21, 1788, with only 39 of the total 74 delegates signing the document. K.W. Royce points out in his book, Hologram of Liberty, a bit of math is illuminating here. The states chose 74 delegates, 19 of whom refused to attend. Of the 55 that showed up on May 14th, 14 left early, leaving 41. Of the 41 that stayed through September, 3 refused to sign. So 34 of the chosen 74 delegates signed the Constitution during the convention, just 53%. Of the original 74, nearly half refused, didn't attend, quit, or didn't sign. After the convention, an additional 5 more delegates would sign, with delegates from Rhode Island holding out for the longest 2 years. When asked why he boycotted the convention, Patrick Henry famously quipped, "Because I smelled a rat." The Anti-Federalists were opponents of ratifying the U.S. Constitution. They feared that it would create an overbearing central government, while the Constitution's proponents promised that this would not happen. As the losers in that debate, they are largely overlooked today, but that does not mean they were wrong or that we are not indebted to them. Notable Anti-Federalists include Patrick Henry, Thomas Jefferson, Thomas Paine, George Mason, and Samuel Adams. Henry would later say, "The Confederation, this same despised government, merits, in my opinion, encomium. It carried us through a long and dangerous war. It rendered us victorious in that conflict with a powerful nation. It has secured us a territory greater than any monarch possesses. And shall a government which has been thus strong and vigorous be accused of imbecility and abandoned for want of energy? Greater danger would allegedly ensue if the Virginia Convention rose without adopting the Constitution. I ask, where is the danger? I see none. Why then tell us of danger to terrify us into an adoption of this new government? And yet, who knows the dangers that this new system may produce? They are out of sight of common people. They cannot foresee latent consequences. I dread the operation of it on the middling and lower class people. It is for them I fear the adoption of this system. I see great jeopardy in this new government. I see none from our present one." Speaking of the system under the Articles of Confederation. "Private and public security are to be found here, and in the highest degree. It is the fortune of a free people not to be intimidated by imaginary dangers, for fear is the passion of slaves." Economics professor Dr. Gary M. Gales points out in his essay, "The Anti-Federalists were right, that in many ways the group has been misnamed. Federalism refers to a system of decentralized government. This group defended states' rights, the very essence of federalism, against the Federalists, who would have been more accurately described as nationalists. Nonetheless, what the so-called Anti-Federalists predicted would be the result of the Constitution turned out to be true in most every respect. The Anti-Federalists warned us that the cost Americans would bear in both liberty and resources for the government that would evolve under the Constitution would rise sharply. That is why their objections led to the Bill of Rights to limit that tendency, though with far too little success that has survived to the present. That's right, we have anti-constitutionalists to thank for the Bill of Rights. Anti-Federalists oppose the Constitution on the grounds that its checks on federal power would be undermined by expansive interpretations of promoting the, quote, general welfare, which would be claimed for nearly every law, and the all laws necessary and proper clause, which would be used to override limits on delegated federal powers, creating a federal government with unwarranted and undelegated powers that were bound to be abused. But even the wise anti-federalists could not foresee the regulatory Leviathan state that would emerge under the auspices of the Commerce Clause, which would come to be called the Everything Clause in law schools across the nation, used by centralizers and bureaucrats to justify almost every conceivable federal intervention into the private economy. The Commerce Clause refers to Article 1, Section 8, Clause 3 of the U.S. Constitution, which gives Congress the power to, quote, regulate commerce with foreign nations and among the several states and with the Indian tribes. Jefferson argued that because fundamentally, sub specie aeternitatis, everything affects everything else. And because of this, the Commerce Clause would lead to an unlimited government. When commenting on the Commerce Clause before ratification, James Madison claimed the clause was not intended to give the federal government a positive power, but instead affirmed a negative power to strike things down that inhibit the freedom of commerce. For example, tariffs that states might impose on one another. To illustrate how broad the interpretation of the Commerce Clause has become because of its inherent ambiguity, consider the Supreme Court case Wickard versus Filburn. A farmer, Roscoe Filburn, was growing wheat for on-farm consumption in Ohio. The U.S. government had established limits on wheat production based on acreage owned by the farmers in order to drive up wheat prices during the Great Depression, and Filburn was growing more than the limits permitted. Filburn was ordered to pay a fine even though he was producing the excess wheat for his own use and had no intention of selling it. The Supreme Court decided that Filburn's wheat growing activities reduced the amount of wheat he would buy on the open market, which is traded nationally, thus affecting interstate commerce. Although Filburn's relatively small amount of production of more wheat than he was allotted would not affect interstate commerce, the court argued that accumulative actions of other farmers, like Filburn, would become substantial. Therefore, according to the court, Filburn's production of food for his own family on his own property could be regulated by the federal government under the Interstate Commerce Clause. In conclusion, constitutions provide an important legal framework with which to defend against the tyranny of the federal government within the current political paradigm. It is certainly better we at least have this Constitution within our current system, which sets a legal framework with which to point out the violations of liberties that are supposed to be protected therein. And to reiterate, there are occasional constitutional wins, but because of the inherent nature of the system, the government itself determining for itself whether or not what it does is unconstitutional, the innate ambiguity of the document that ensured the quick usurpation, misapplication, and misinterpretation of its important precedents, along with the lack of personal incentive that exists for private citizens to engage in public affairs, makes the United States Constitution an inadequate device for maintaining economic and personal freedom and reining in the federal government in the 21st century.